For this final panel, we've got Justice Mirza of the Superior Court, who's generously donated time to come and speak to us about matters involving bail. We've got Matthew Shumka, an experienced assistant crown attorney, and Tonya Kent, an excellent defense lawyer. In this panel, what we were hoping to cover were some of the issues that have arisen recently in the case law surrounding bail and bail reviews, and some topics that I feel deserve special attention. One is really the importance of section 493.2 of the Criminal Code, what it's designed to address, what have the Superior Court judgments been saying about it in particular, and also the issue of jail conditions as a factor to be considered at a bail hearing as opposed to a sentencing hearing. And what, if anything, has been said about that recently? Let's find out. Okay, so Justice Mirza, I'm going to start with you. Can you please step us through what you think counsel should know that's most important about bail reviews and Myers reviews and 483.2?
Okay, sure. First of all, good afternoon, everybody. It's very nice to be with all of you, and thank you to the organizers for putting together a wonderful event. I have been watching online this morning as I was getting ready and in the car on the way here so that I could take in as much as possible. And I thought that the discussions so far have been excellent. The questions have been very good. So your dedication and commitment to come here on a Saturday, on a beautiful day, to talk about bail, all of you that are here and all of the organizers is very impressive. So thanks for having me. With respect to what I want to assist with today and contribute, in the Superior Court, as you're aware, we deal with bail reviews and detention reviews. And in the most serious offense, we will deal with bail of first instance. Now, I'll put an asterisk there because at a bail review or a detention review, we also do bail de novos if there's a material change that's made out. So in that way, we also operate as a court of first instance if you get past that barrier. So for us, what is important is written advocacy. I know that you've spoken a lot today about oral advocacy, about being prepared, working with sureties, doing those types of things. But written advocacy is extremely important in the Superior Court. And it is your first impression to the court. When we walk in on the morning of, we've had a chance to review your materials, leaves us with a very clear impression about the time and commitment you've put into the materials. They're often very good. At times, there are aspects that are deficient, and I want to talk about sort of the first principles here and making sure that you remind yourself that effective written advocacy, particularly for newer lawyers, sort of getting their grounding in terms of the oral advocacy, your comfort in court. I get it. We've all been there. You know, a bit of anxiety, the more serious the offense, dealing with a strident crown that's, you know, taking a very restrictive position. You know, your written advocacy is your way to get your point across pretty effectively in front of a court. And it's nice to see Nader Hassan here as well. I can tell you that, you know, a case that has to be in your toolkit now is the Zamir bail decision. And what you will see there are a few things that stand out to me. It was recently submitted to me in a bail. And so reviewing it, you know, one is the written advocacy. You can see the reliance of Justice Copeland on the written materials that are submitted. It's professionalizing the bail process. The second is the evidence that was called when it was contested with respect to the GPS monitoring. Again, as a service to the administration of justice, that I understand from the earlier panel, you know, you don't have to call the people from recovery science, but because that bail was so high profile and so heavily contested, nothing was taken for granted. And what you see there is the ruling from the judge that indicates how the technology works and why ultimately she says, here's a body of case law that tells us that this is an effective tool combined with a strong surety plan that you can rely on. So it's very important that sort of keep that in mind when you're appearing in Superior Court. Okay, so what am I talking about in particular in substance? The client's affidavit. Okay, the criminal rules, Rule 20 in particular, tell you what needs to be in the affidavit. No shortcuts. You know, one of the criteria, for instance, is what is the person's employment history? You may look at that and say, well, what's the big deal around that? Well, one of the questions is, how is the person going to support themselves if they're released? To house arrest bail and they're totally relying on their surety and they can't go out, okay. But all of you are going to argue for something less onerous. You're going to want to argue for exceptions. You're going to want to argue for those things. And so being able to demonstrate who they are, that dovetails as well into the 493.2 issues, which I'll get to shortly. Okay. Identify with detail the bail plan that you're proposing. Okay. Another first step in the advocacy. This is the plan that we propose is reasonable, right? This is why we say it's justified and more onerous conditions implicitly are not required. Have a discussion with the Crown about what you're proposing. Ask them, if there was release, what would you be asking for in terms of conditions? That does two things. One, tells you what to anticipate and what you might need to address in your submissions. And two, it gives you an indication as to where the Crown stands on that. Okay? The other part, don't lose sight of the difficult role that the jurist has, which is they have to balance, yes, the presumption of innocence, yes, the right to reasonable bail, with the public safety and victim safety concerns. The more you get ahead of that, the better your advocacy is, because it demonstrates that you've considered both sides of the equation and you can justify your position. So the criminal code requires the judge to turn their mind to public and victim safety. And that is often where there's going to be a discourse about what are reasonable conditions. Okay, so remember just the broader theme. The takeaway here is, why are you there? The quintessential question in bail is, what does it take to restore the liberty of the accused with reasonable conditions? And that's the theme that should permeate your written submissions.
Do you want to comment on 493.2 while we're here? And then we'll go down the table.
Okay, all right. So 493.2 is obligatory. And you're seeing, from my perspective, Justice of the Peace doing a very good job consistently and specifically addressing the requirements of 493.2. So I'll just refresh your memory about what the section says. In making a decision under this part, a peace officer, justice, or judge shall give particular attention to the circumstances of Aboriginal accused and accused who belong to a vulnerable population that is overrepresented in the criminal justice system and that is disadvantaged in obtaining bail. So there's two components to that. One is it animates the principle of restraint, which is also covered in 493.1, but it gives added emphasis to that. The second is that it's a specific acknowledgement, in my view, of the historical injustices in the bail context towards people from marginalized communities and the importance of a remedial approach to the analysis of bail. Now, to be clear, if the Crown's case is strong in the secondary and tertiary grounds, it's unlikely that simply averting to the individual's background is going to get to the destination of release. However, it can also tip the scales in favor of release if you use it properly to contextualize, for instance, if the person has a criminal record with 2 breach of bails on it. Okay? If you're able to talk to the client and figure out what those related to, were they actually in relation to breaching conditions that were likely too onerous at the time, that predate the case law in Zora, you know, that's an opportunity for you to explain that. Okay, that can also dovetail with the issues which are now widely acknowledged, that some communities are over-policed, okay, that there's disproportionate contacts with the police. And so it's an opportunity to contextualize that. What I'm suggesting to you, and this is subject to your independent assessment with respect to strategy and what's in your client's best interest and the overall picture of how you want to advocate. Okay, I give due deference to that. But what I'm suggesting to you is that when you think it's appropriate to include this information, because we have to deal with it. We have no choice. Put a separate heading in your affidavit for your client that indicates their relevant personal circumstances, who they are, where they come from, the community that they live in, their prior difficulties and disadvantages, both systemic and direct, that give the court an opportunity to understand what they're dealing with. Historically, what we know is, and it was interesting to me when I was listening earlier when you were talking about sureties and plans and can you release without a surety and so on. Okay, look, first of all, when you're in superior court and you're at a bail review, the idea of being released without a surety, it's going to be rare. Okay, because of the seriousness of the offense that you're dealing with. That being said, if it's a situation where you're closing in on time served and so on, there's always going to be exceptions to what I'm saying. But generally speaking, you're talking about, you know, offenses that are alleged that are likely, if the person is found guilty, going to command significant periods of jail. Okay, often crimes that involve, you know, significant violence towards victims or risk factors to the community. So surety bail is going to be important in that context, right? It's helping, 493.2 helps contextualize all of this information and apply that information better. Because we know historically, people from marginalized communities have been unjustly viewed as higher risk. They're stereotyped essentially as soon as they walk into court. Oh, you come from that community where there's higher crime, you're more at risk, you're going to associate with people that are more at risk. You need to dispel these stereotypes and bring it back to an equality base. And that's the opportunity you have with 493.2. So address it in your client's affidavit. Also address it in the surety's affidavit. The surety can provide additional contextual information. If they're a family member, they can speak to their experience as well, right? Look, there is a bias in a lot of these serious cases that one surety is not enough. But if that's all the person has, because that's their family dynamic, and that person is going to provide meaningful supervision, then that's part of the story that you have to tell the court. And that sort of brings it back to a baseline of equality. Not everybody is advantaged or situated by having the benefit of extended support systems or people with significant assets or, you know, extended networks. And so that's why I say it's very important.
Fantastic. Tonya, I understand there are some recent cases you'd like to tell us about and maybe a little bit about Simonelli applications.
Yes, so I actually can I first touch on
Yeah.
sort of what His Honor was saying. There's a case called Queen versus Khan, 2024, ONSC 4630. And this is a case, I think His Honor has already touched on 493.2. But I did want to touch on also talking about pretrial jail conditions and how important that is, particularly in regards to that case, in regards to that, and including that in the affidavit. So for example, when we all know our clients forever miss access defense calls, when you're writing to the jail about it or calling about it, making sure to add that information in as well. How many times they've missed the calls, how many times you've contacted the jail about it. This still goes to all the factors of the conditions in jail, visits, video calls, even with not just you as counsel, but also family. So I just wanted to touch on that because His Honor was talking about what we're including in the person's affidavits. But I'll go back to the Simonelli case, or sorry, Simonelli type applications. And I think the first thing that everyone needs to do is look at section 503 of the criminal code. It's black and white, that a person shall be taken before a justice without unreasonable delay. Queen versus Poirier of the Ontario Court of Appeal also touches on that, which is POIRIER 2016 ONCA 582 at paragraph 58, and notes that complying with 503 is not just a matter of form and it must be followed. So not just simply putting someone before the court and be like, well, you appeared. There has to be a meaningful appearance. And I think that also in regards to the Simonelli applications, what you have to make sure that you're doing is if you are noticing that if your client is in custody, and this is like right at the beginning usually at the Ontario Court of Justice, I'm not saying it would never happen at the Superior Court, but I don't see the same type of thing happening just because of the way the bails that the Superior Court deals with initially. But when we're talking about bails at the OCJ, the first thing, you know, obviously showing up for your client and making sure that you're there to say, hey, I'm ready to go. And if there's delay and if there's issues with that, don't be afraid to say on record. I know that bail court sometimes can be kind of fast paced and fast moving. Everyone just wants to get through the list, but you have to stand up for your client and be able to say, look, we're ready. I have my surety or I have my plan ready to go and we're here. And if there's an issue then about getting delayed, and let's say you're getting adjourned because they're like, well, sorry, we don't have time. You need to step in and make a comment to be like, look, I'm counsel. I was here. I was ready. This is the time I've been ready since. I'm not, I don't want to agree to go to whatever the next day or the day after, but I'm ready now. If it's being adjourned, it's being adjourned because the court is adjourning it, not because I'm asking for this adjournment. Be very clear about that so that there's no question and issue when you're ready to bring your application. And when we're talking about that as well, not only just saying those things on record, but if necessary, because sometimes with special bails, you're ending up emailing the trial coordinator or the Crowns, putting that in your email saying, look, this is not an appropriate, you know, I think to some extent, I think the Toronto Regional Bail Court is getting better in regards to special hearings. I'm noticing that the dates generally are available, but if there was an issue, and there's other jurisdictions, not just Toronto, but if it wasn't available, you putting in writing and saying, look, I have told you that these are my available dates. This is not an acceptable date. I'm accepting it because this is what you're offering me if it's decided that it's a special bail, but I am not accepting these dates, because those emails then become a part of your record as well when you're filing these applications. And particularly 516 also of the criminal code is also important when we're talking about adjournment of proceedings, because it's not longer than 3 days unless the accused person is consenting. So it doesn't mean that routine adjournments of bail are acceptable. And it's considered an unacceptable threat to constitutional rights, as it's a denial of access to justice, and it's an unnecessary cost to the court system to have people constantly returning and not getting things done. And so when we're talking about these applications, so if you've kind of decided you're in the situation where you've had an unreasonable delay for bail, one of the things that you need to do is, one, demonstrate that a prejudice will be manifested, perpetuated, and aggravated through the conduct of the trial or its outcome. Two, that there's no adequate or alternative remedy that's available. And three, that the interests of society favor a stay. And how you sort of have to do this is, and this is kind of like a hard part, and I feel like the defense bar really needs to come together to ensure that we can do this sort of, I will say, on a regular basis, to make sure that the courts understand that, like, this needs to be dealt with, and we can't just play around with people's rights when it comes to bail. You kind of have to show a continuing breach, and how you show that is sort of getting transcripts, talking to your other colleagues to find out, okay, did this happen to you in this jurisdiction, so that you can go. And I know that there's a cost obviously involved in that, and that's I thankfully he's not here. Chris Suratin worked with me on a case that I did called Queen versus Al-Hajj Salem, and that's ALHAJSALEM and 2023 OCJ 2388. And thankfully I had Chris Suratin, who I think he had done one previously, but they just withdrew the charge, so he wasn't able to argue it. And then so he already had some transcripts in Newmarket of showing that this thing had already happened 3 different times. So showing that this is a continuing breach. So sometimes you're either hiring a court reporter to get sampling. What he had done, I remember he told me, is that he hired a student to sit in the court and know when these things are happening, so that you can order those transcripts. And the transcripts might not be so onerous because they might be quite short, because it's just like dealing with a particular matter, and showing that there's no adequate remedy available. So you kind of have to show how egregious that this situation is, and showing, look, this keeps happening in this, in this jurisdiction. This has now happened to my client, and there's no other adequate alternative remedy. So usually, if in the situation for the case I just said, we did it as we set the trial down for the matter and then had the application before the trial. So if there was a stay, then the trial dates would no longer be necessary. And so we were sort of saying he waited 16 days. That's completely unacceptable. And that the only way is a stay. Usually the Crown will argue and say, well, you can do a sentence reduction, but we obviously argued against that. And then obviously pointing out that the interests of society favors a stay in the circumstances. And sort of how you get those things done is, like I said, is protecting the record very seriously, not only orally, but also by paper if necessary, so that you have those things to discuss. And some of the things I think when we're talking about pretrial conditions, I think also and now I don't remember if I had an affidavit for him. We must have, but I think like looking back now, hindsight, I think what I would have done also, I think he was at Central East, which was like, we all know, notoriously terrible. Not that all aren't terrible, but Central East has its own problems. But we were able to talk about sort of that sort of issue of saying, look, also he's there for 16 days under these types of conditions. Like these are the things that are happening. He's far away. We didn't go that far into it. And I don't think the case of Nanny Bush was out at the time. So I probably, if it was, I probably would have used it and talked about it, but it wasn't there at the time. So I think when we're, just to kind of wrap up on the Simonelli applications, when we're talking about that, remembering to protect the record, remembering that don't be afraid to do it. Like I know sometimes JPs will try to cut you off and they're not necessarily doing it personally against you, but it might be just like they're to get things moving, but that just can't be how the court is operating. You have to take a stand and just say, no, like I need to put these comments on record. And that's what needs to happen. And really working together, because we're all here as defense counsel, really working together to get those transcripts, to get those anecdotal stories so you can find those transcripts so that we can start arguing those more often if that's a problem in your jurisdiction.
Any of the other, or Matt, do you want to chime in?
No, I'll chime in and I'll start off by saying thank you for having me. I very much enjoy coming to these kind of events and frankly speaking with my colleagues in the defense bar and the bench. I think that gives you the best platform for having meaningful, engaging discussions on these topics. And like all soldiers of bureaucracy, I have to say at the outset, my views, and I have many, are my own. I don't speak for the Ministry of the Attorney General. I don't speak for the Ontario Crown Attorneys Association. That being said,
It's gonna be good.
Let me begin by talking about where Tonya left off with Simonelli applications. I don't have a lot to add, at least as it relates to the law. Section 503 is clear, 24 hours, you're in front of a justice of the peace. If we're talking about investigatory remands, 3 clear days, no more. And as Tonya discussed, the potential ramifications for breaches of these sections can be quite significant. The proceedings can be stayed. That is a drastic remedy of last resort. And the whole case could be over before it starts. And the courts quite clearly take these provisions seriously by virtue of those types of remedies. And they should, because it's the law. And as Crowns, we don't get to cherry pick which provisions in the code will follow. These are as much as the law as are the reverse onus provisions under 515 sub 6. So with a view to that, I want to focus on 2 areas of practical advice, 2 issues I'd like to speak about for all the Crowns listening, the potential Crowns listening. We are recruiting, keep that in mind. But let me talk about, I know, come on down, Tonya. Let me talk about overloaded lists, and let me talk about police requests for investigatory remands. Overloaded lists. This is not a secret as it relates to Toronto. We're busy. We are really busy. We're tired. It is exhausting and it's difficult. And when you're in court with 15 people lined up for a bail hearing and 6 of them have signaled, we want our hearing, hearings, even simple ones, submissions only, you might not get through all of them. So there's your scenario. Tonya's ready to go. Her client is there. She's covering the record. She's saying, it's been 2 days. This is the 2nd time I'm getting kicked over. My client has a right to have this hearing. This is a problem. She's saying it politely, firmly. She's covering the record. She's building a record. Tomorrow is the last chance to get this on. Crowns, what do? 3 things. First, listen. Do not ignore these comments and concerns. That's your Simonelli application in motion. They're telling you about it. They're telling you what they're going to do. And this is what the Superior Court is going to be reviewing. Second, with a view to that, prioritize and flag these matters. Talk to if you have one, a bail coordinator, or even if it's just your colleague in court the next day, very simple conversation. You better get this one started right at 10 a.m. or we're going to have a problem. And then third, triage if necessary. Look squarely at the reality of the situation you're facing. I am not going to get through all of these. This bail plan is not ideal in my circumstance, in my assessment. I get it. However, I'm going to consent in the circumstances because better a comparatively lax bail than the charges getting thrown out. Now, lastly, and let me preface this by saying I am not giving advice to defense counsel. This is more of a preview of a counterpoint you might encounter from the Crown. If you're thinking about building a Simonelli record and you're coming up on day 3 and the Crown says, we can do this at 10, we've got you covered, make sure your surety's there. Make sure that you're not late, because if I'm standing there at 10 a.m. and your surety doesn't come till 11:30 and we could have done the hearing in that particular window, you better believe I'm covering the record in that scenario. And I'm not so obtuse as to recognize that sureties don't have jobs, lives, other commitments. And I'm not saying that that's necessarily going to be determinative on a Simonelli application, but you need to be mindful of that reality as well. If this is something you're thinking about and you really are pressing this notion that we want to have this hearing going, be as prepared and as ready as you can in the circumstances. The next area, requests for investigatory remands. Request underlined. You get a call from a detective saying, can you please remand this 3 days? Grounds, if you encounter one of these requests, do not simply nod along and say, sure, I'll ask. Recall that the 3-day mechanism is discretionary in nature on the part of the jurist. It is not mandatory. So I strongly encourage you to dig into your cross-examination toolbox and ask such blistering questions as, wait for it, why? You better believe your judge is going to ask you that. So, and you might not be able to give the answer you get fulsomely on the record. You may well have a scenario, well, we're waiting on an ITO to come back for a search warrant right now. We are kicking in the door to that apartment. We expect to find a pile of drugs and guns, and we can't have them knowing about it, but we also don't want them out and moving the stuff now that we've arrested them on other things. Perfectly reasonable answer. And you obviously can't let the cat out of the bag on the record on that point when you're going back to court, but you can now say, in good faith, your worship, I've made appropriate inquiries. I have satisfied myself as to the validity of this request. And that being said, I'm only asking for 1 day in lieu of 3 based on the information received. That's perfectly valid. That is consistent with your ethical obligations. That is consistent with you making good faith submissions. And now it's not, why do you need 3 days? Instead of saying, I don't know, you have a substantially better answer to put forward. I'm going to comment very briefly on some of the comments that have made on the significance of section 493.2 and vulnerability. This is going to lead into me making some commentary on a case that may or may not have been mentioned today, Nana Bush. I'm not sure if it came up or not. But when you're
popular in your office, I'm told.
That's it. When you're considering the scope, the breadth of what the provisions 493.1 restraint, 493.2 overrepresentation of Indigenous and vulnerable persons in custody, it's really important to consider where these provisions appear under Part 16 of the code. Again, Part 16 encompassing everything to do with judicial interim release. They're at the beginning. They're right at the start of the bail provisions, and they were enacted in 2019. And their placement as principles of interpretation at the outset of Part 16 matters. As a matter of statutory interpretation, this part's easy. It means that everything in the bail sections needs to be viewed and assessed through these lenses. That's the law. Now, that's the law. What that means, practically speaking, mind you, that's a whole different question. And confess conceptually, I've often had trouble reconciling what this means, what these new provisions mean, with how we have traditionally thought about bail and the primary, secondary, and tertiary ground. And perhaps that's the point, is to think about it differently. And let me unpack that a bit. If we're talking about public confidence in the administration of justice, tertiary ground, I have no difficulty whatsoever. An informed, reasonable, a right-thinking member of the public can easily be conceptualized as considering restraint and overrepresentation of Indigenous and vulnerable persons. But what does it mean for the primary and secondary ground? I've always thought of that in a very binary sense. You're a flight risk or you're not. You're a risk to public safety or you're not. Tertiary, I get. Primary and secondary, I struggle with. But here's the thing. My conceptual struggles amount to absolutely nothing. because these provisions are at the forefront of the bail section. If Parliament wanted to ground these provisions under the tertiary ground under 515.10c, where they already have a nice little handy list of sections to consider, they would have done it, and they didn't. And so what this means, practically speaking, for your client, your vulnerable client in a carceral setting, these provisions are, comparatively speaking, new law. What do they mean going forward? You're the lawyers. Argue it, build a record, put the evidence before the court of your client's background, who they are, what's going on in a custodial environment, because I don't know how these provisions can be interpreted judicially, but for an evidentiary record that gives a platform for that consideration. Now, as it relates to what that actually looks like, practically speaking, the Nanabush decision is quite interesting. And the way to kind of set that up, what it ends up kind of setting out is you have a recidivist offender. He is a very, very sad story. He has Indigenous heritage, and his record is for non-violent offenses predominantly. It's a reverse onus. Crown's asserting secondary ground concerns, and we're looking at another slew of non-violent offenses. And as His Honor indicated, they called the client to talk about, this is what I have experienced, this is what I have gone through. And the link to not just his individual background quickly shifts over to his experiences in a carceral setting. And there's a good deal of evidence presented about the difficulties he has had in this particular carceral setting at the Toronto South Detention Centre. And relying on the 493.2 principles, His Honor, and I'm not asking you to comment on your own decision, but His Honor explicitly links those provisions.
Ask some questions.
Explicitly links those adverse conditions and links them to 493.2. And when you read the decision, it quite clearly becomes a make weight in determining that this particular individual has met their onus under the secondary grounds in those circumstances. Now, that consideration of adverse pretrial conditions, we see that all the time in sentencing. Will we start seeing it more in bail settings? I don't know. But as an interesting point, yesterday, the Court of Appeal released their bail decision for Hogarth. And it's short, so I can summarize it quickly. But they talk, one of the issues they grapple with is evidence put forward and arguments made about the pre-sentence conditions post-sentence conditions he was facing for his bail pending appeal to seek leave to the Supreme Court. And essentially the evidence was, I'm very famous, my case is infamous, and I need to be in protective solitary custody, which is extra hard. I am paraphrasing somewhat. But the response was, evidentiary-wise, he asked to be put in protective custody. So Crowns, think about tendering that kind of evidence if it exists. Again, I paraphrase. But Her Honor goes on to say at paragraph 22 of the decision, Justice Copeland says, a lot was put forward about this. I don't need to deal with this because he's about to get moved to start serving his sentence. So this is not something that's going to inform the decision. Of critical note, Her Honor does not say this is irrelevant. Quite interestingly. I don't know where this is going, but it's very possible that we're going to start to see more information about this to further inform the interpretation in a practical sense of Section 493.2. I think I can stop there, but that's certainly, I think, Nanabush has really got people to talking a lot about this, because if the idea is harsh pre-sentence conditions is merely a windfall game for people who are convicted and sentenced, perhaps the law is evolving past that in our understanding of these settings.
Okay.
And can I just add about
Yeah.
the nanny bush, just because we're on it, is even though it is talking about, because Your Honor, I've definitely used it a lot of times. But if even though it's talking about Toronto South, I have used it even in talking about other in other jurisdictions. So I've used it in Peel, I've used it, I think I forgot where else, but I used it somewhere else as well. Because even though it's not talking about any other institution, I think it would be very hard for a Crown to get up and say, no, these other jails are totally fine. Number one. And number two, in conjunction with all your other stuff. So if you're going to talk about the access defense calls, you're going to talk about, you know, the triple bunking is, I think, a bit hard to talk about. But if we're talking about particularly access defense, particularly business, particularly lockdowns, I think it's still relevant, because if you talk about those things and then bring the case of Nanny Bush in, so it's hard for someone to say, because I'm going to say, well, the same things that are being discussed in this case are happening at this jail. So therefore, this is relevant. And particularly, I would just want to note, looking at paragraph 52 and 53, what's noting exactly that it has to be considered, and talking about also the effect on people mentally and emotionally. And paragraph 77, which I did like, it notes conditions at the jail as being inhumane, and especially considering the fact that individuals have not been found guilty of an offense at that point. So just like kind of going on the importance of getting that information. I know we can't for like cases where you're running a bail like right the next day, but if people are waiting for the bail anyways, you might as well gather that information so that you can at least compare it to the case as well, even though you're not talking about Toronto South Detention Center, you may be talking about a different detention center. Like I plan to use it for one, talking about Toronto East, because my client just called and said he got scabies, which is a super old disease, and I was really surprised by that. But I'm still going to talk about it, even though it doesn't talk about Toronto East.
Well, let me ask you, Justice Mirza, can you comment on this at all? I mean, if you're hearing a bail matter at Superior Court in any capacity, are the jail conditions a relevant factor to consider, or are they just, sometimes I hear from the grounds, they're just not relevant on the secondary grounds, for example?
The jail conditions are a standalone, independent, relevant factor. The Court of Appeal in Powell 2020 ONCA 743 specifically acknowledged that one option to deal with harsh and unjust jail conditions is to bring a fresh bail application. So on its own, it's a basis for you to argue for bail. Now, when you bring a bail application and you're, doing it on the basis of a plan, whether it's a review or detention review, that can also be part of the relevant information that you're going to put before the court. But if it's descended into something extremely grave, you could bring that as a basis for bail on its own. Look, we have a body of Supreme Court case law now that I think recognizes that the conditions in pretrial custody have been problematic on a number of different grounds. So if you do have a client that is struggling in that environment, you also now have a body of case law, to Tonya's point, not just in Toronto, but there's at least 10 decisions now out of Central West on sentencing that talk about how difficult the jail conditions are. And so those are not restricted to just sentencing, they would be relevant to bail as well.
And I might add as well, if the question is how are the jail conditions relevant to the secondary ground, in the strictest sense, I don't think they are, but I do think they're relevant to the consideration of 493.2, which is why I make the point that I think they're an interpretive lens through which you have to assess all the grounds. So if the concept becomes, how do they inform the secondary ground analysis? I don't see it. However, looking at the entire bail section, that's, I think, where the grounding comes, in my view, at least.
The conditions of the jail is having some good deterrent effect on the accused, and that it's incentivizing them to apply to avoid going back, particularly harsh conditions.
It's a good question. Does it serve as a motivator, essentially? I think that the answer would be, if there's evidence of that, sure. If you have an affidavit from the accuser, you hear that, then you have an evidentiary basis to say that. But if I'm dealing with someone who has 12 breaches on their record and is in and out of jail on the regular, and on their last release, and here we are again, they would have been in the same institution weeks ago. It's not a big conceptual link. I think say, well, it didn't deter them then, why would it deter them now? Being careful not to import sentencing principles into the bail setting. I should be clear. My point is, I do think it is relevant. I just think it's how you think of relevance and how you interpret these provisions is important.
What I'm hearing is Matt saying Nana Bush was rightly decided. That's all I care about. Okay, so we only got a bit of time left for this panel. Look, Matt, did you have some other recent Superior Court authority you thought was important for us to know about?
I'll try to summarize it briefly, and what I'll do is I'll just get to like the real takeaway from these decisions, and it's two decisions that operate in tandem. The first is, it's sometimes reported as Sergeant or CS, but the idea here is, in a reverse onus setting, there is no such thing as bail set not met. It does not exist. If you do not satisfy your onus, you are detained, which is consistent with the strict wording of the textual wording of 515 sub 6. If you wanted to unpack the analysis, quite simply, bail set not met is grounded under section 515 2.1. That's the authorizing provision. 2.1 makes explicit reference to pursuant to a release under 515 sub 2, which is crown onus and the latter principle. That's where the authority comes from. The decision says 515.6 and 515.2 don't talk to each other. This is just plain contextual statutory interpretation. So in essence, if you don't meet your onus, you get detained. So that's what Sargent says. There was some conceptual friction about the application of Sargent, and I've had to, when saying his worship just a short, I had a bit of a back and forth as well. This is binding on me or not, because there's conflicting Superior Court jurisprudence on this point, and where do we go from there? And the answer became, well, if we talk about horizontal stare decisis in Sullivan, which I could spend a whole day talking about.
Please don't.
I know, it's exciting. I think so. That's the answer, is that this is the most recent decision. It was not decided per curiam. It is binding horizontally in all our Superior Court judges and vertically on this court. And the review went up on that very point. And Justice Barrett of the Superior Court said, listen, not only there was conflicting jurisprudence that wasn't addressed in the Sargent decision, but not only is it vertically binding, I am bound to follow Justice Abraham's decision on this pure point of law. So practically speaking, what this means is if you're in a reverse onus, there is no such thing as bail settlement. And I don't think that changes absent statutory intervention in the circumstances, absent further legislation. Given that, Tonya, when you're going into that kind of setting, a reverse onus setting, do you prepare your clients or sureties any differently as you would a crown onus?
Yes, because I'll make sure that one, they understand that there is no bail set not met. So please come forward with the best plan. So sometimes we know clients are in a rush to get out. So maybe the best person isn't available, but they're like, sure, like my brother will do it. It's not the best situation, but he's going to do it. Please try to advise your client not to do something like that. And it's better to wait a day or two for the better plan, because once you're in that reverse onus, if you're detained, you're detained. And now we're in a bail review situation where we're having to order transcripts. And you know, if the client is on legal aid, you have to get permission before you order the transcript. So things just get elongated. So I personally prepare them and tell them, and like, I'll obviously follow their instructions, but I heavily tell them to say, this is your onus. So if, you know, it might be that the justice thinks you're releasable, but they're not going to be in a position to be able to put the bail set not met in place, which I used to rely on before. So just know that before you're deciding to just rush off. Like some people say, let me just do it on my own or whatever. You know, so-and-so's not available till Wednesday. Please don't do that, because then what happens is, and this is more of a practical consideration, when people are in custody, they tend to be more annoying. So I would rather you be out so that you're less annoying. But I wanted to also come back and touch on the secondary grounds in regards to Con. The case that and I'm going to say it again, it is 2024 ONSC 4630. I only read it the other day and was there's a lot of stuff in there. But one of the things I wanted to point out about the conditions, because Matthew's saying that, like, you know, maybe it doesn't come back to the secondary ground. But one of the conditions, particularly in this case, was the person was transferred for some reason from Maplehurst to Sudbury jail, 4 hours north. So there was the court considered to say, like, a person looking at the tertiary grounds, and then I guess, you know, and the whole situation of saying the person's not receiving emotional support. The member of the public that's reasonable would consider that people need constant access to their lawyer and their family for a full answer in defense, because it's nonsensical that if someone is transferred to Sudbury, obviously their lawyer's not in Sudbury because the case happened in like Peel. So it's not reasonable to expect a lawyer to drive 4 hours one way to like show your disclosure, to go through all these things. And I thought that was an important consideration that the court made, and talking about the fact that the person doesn't have support of family members and all of that. And that's an important consideration as well that the court made. So I did want to kind of run back to, I guess it doesn't really deal with secondary grounds, but just in general as a whole, part of the situation. Because if it goes to, I think someone at the front asked a question about whether that sort of deters someone. I think if I went to a jail in Sudbury 4 hours away from my family, I would for sure be deterred. So there's that as well too, that you could sort of talk about, especially something like that, because I think that's super like intense that someone was sent out that far away. But that's what I just wanted to note.
And it's a good point you make. Just, you know, what's relevant in the circumstances. You don't need to be too mechanical about it. you know what's relevant when you hear it. Articulating why might be a different variable, but if you're talking about the human element of shipping this guy 4 hours away from his family, his lawyer who he has to consult with, that's got to factor in somewhere. I don't think that's irrelevant. And if it's not irrelevant, it's relevant.
We had one
Uh,
question come in online, just was whether or not mental health issues for an accused person should fall under 493.2. I think the answer to that is obviously yes. And there's a great decision from Justice Schreck that I relied on in Nana Bush that really goes over all these analogous grounds if you need that. Otherwise, I'm gonna have to bring this panel to a conclusion just so Maya and I can finish up before we get the proverbial boot out of the room. But thank you so much for coming. It was absolutely excellent. I really, really appreciate it.